All right. Welcome back for my second video of the day. I'm totally not recording this right after recording my previous video on quick update on the delete laws to Castro versus Abrams, except I actually am. So, hi there. I'm back. So, I've got an presumably even quicker update on Scofield versus Guillard, the TikTok psychic case. So, if you recall, looking at the caption in the docket so that you know we're really on Scofield versus Guillard. So, most recently, we were here in the middle of May for the new answer from Miss Guillard, the psychic, the new answer with the new counterclaims, and it was even more ridiculous than last time. And I'm not going to do the math, but we should see an answer to the counterclaims this week. But in a sign that Magistrate Judge Edward Patrico or Patricio, or I don't know how to pronounce his name, but the one of two magistrate judges in the federal district of Idaho is not messing around. He is, well, let's face it, there's two federal judges and two magistrate judges for the entire state of Idaho, which is 1.5 million people ish off the top of my head. So, it's a very small judiciary. So they can't have cases languishing. They've got to be efficient. And if anything, that's what I'm getting from today's update is it's an order from the judge, scheduling order. And it also indicates to me that despite the TikTok psychic kind of, although inappropriately, asking for the case to be dismissed, but also it's just, it's a whole big mess. She wants it dismissed for lack of jurisdiction, lack of, improper venue, but she wants her counterclaims in Idaho because it's the proper venue for those. And well, yeah, we knew that the magistrate was not going to dismiss it was ridiculous, but this is a little indication, I think, that hey, we're staying in Idaho and we are moving on. So from the docket, it is docket number 21, and it's litigation order and notice of telephonic scheduling conference. The court will conduct a telephonic scheduling conference on Thursday, July 6th, 2023 at 1:30 p.m. Mountain Time for purposes of confirming deadlines proposed by the parties in the joint litigation plan. On or before Thursday, June 29th, 2023, the parties must file with the court the joint litigation plan and discovery plans, signed by U.S. Magistrate Judge Raymond Edward Patrico Jr. So basically, in order to do discovery, you've got to have a discovery plan. It lays out basically when the deadlines are for providing discovery and fun stuff like that. And the litigation plan, it's basically, it's going to be the schedule. It's, this is the time period that we're allotting for discovery. Pre-trials here, close of motions here, pre-trial here, and then trial. So it's penciled in as opposed to written in ink or carved in stone, but it'll give a pretty good idea of the plan going forward. So, that said, though, let's look at the order that the magistrate judge submitted with this docket entry. So it's captioned litigation order and notice of telephonic scheduling conference. They're always a good place to start. Therefore, therefore, it is hereby ordered as follows. 1. Plaintiff must serve this order on all parties who have not entered an appearance via PACER to date. Although I think all parties have now entered via PACER. Well, yeah, technically, although improperly, Ashley Guillard is trying to sue the attorneys, but that we're going to ignore that at least for now. And she's on PACER. The attorneys are on PACER because they filed for Ashley Guillard, or for Professor Scofield, sorry, against Ashley Guillard. Within 30 days of the filing of the complaint, the plaintiffs must file with the court a status report regarding service of the summons and complaint pursuant to District of Idaho Local Rule 4.1. With the footnote 1, the court's local rules may be found at the following URL address. Alternatively, plaintiffs may file proof of service in lieu of the status report otherwise required. So we already have the proof of service. We've seen all the shenanigans regarding service, especially of service of the default motion that service was refused on. So that's kind of irrelevant at this point. Number 3, or hang on. Yeah. Number 3, pursuant to District of Idaho Local Rule 16.1, the parties must meet and determine a litigation plan and a discovery plan, including the issues related to discovery of electronically stored information, if either party contemplates such discovery. The court's litigation plan form and the discovery plan form may be found on the district court's website at that URL under forms, with footnote 2 giving the URL again. And the good magistrate needs to oil his space bar, apparently, because discovery and be found are both combined into one word. And B, if the case is suitable for the court's alternative dispute resolution program, which type of ADR process is best suited to the specific circumstances of the case, and when the most appropriate time would be for the ADR session to be held. District of Idaho Local Rule 16.4. So basically, they should discuss, hey, can we get this done in some sort of mediation instead of, taking up precious judicial resources that, as we can see, are very precious in Idaho because they have a tiny federal judiciary. 4, initial disclosures must be made by the parties pursuant to Federal Rule of Civil Procedure 26.1 and District of Idaho Local Rule 16.1. 5, if this matter is assigned to a magistrate judge, it is, counsel must review and be familiar with District of Idaho Local Rule 73.1 regarding the consent process for proceeding before a magistrate judge. Additional information about the consent process, also one word, process, may be found on the court's website. Footnote 3 is probably also a URL, even though It's got an embedded hyperlink. Well, I would have assumed an embedded hyperlink since it's in blue and underlined, but it's not. It's not flashing as a hyperlink, so unless the plaintiff contacts the courtroom deputy, Jackie Hildebrand, and requests a different date and time, the court will conduct a telephonic scheduling conference on Thursday, July 6th, 2023, 1:30 p.m. Mountain Time, for purpose of confirming the deadlines proposed by the parties in the joint litigation plan. Counsel must initiate the conference call by calling the court's conferencing line at the telephone number. On or before Thursday, June 29th, 2023, the parties must file with the court the joint litigation plan and discovery plans, dated June 1st, 2023, and signed with a fancy seal by Raymond E. Patrico, Chief U.S. Magistrate Judge. So that's a basic roadmap of what we're looking at over the next month to month and a half in Scofield versus Guillard. But like I said, expect a answer, or it might not be an answer, and you'll see why in the video I do later this weekend on the Delete Laws Las Vegas case. But basically, I expect a motion to dismiss, not an answer, but either way, I expect it this week. So that's the full roadmap looking ahead in Scofield versus Guillard. And with that, I will see you hopefully later this weekend for the big video on DeCastro versus LVMPD. Do all the YouTubey things again. Like, share, subscribe, and I will see you soon. Thanks for joining me.